judicial legislation, which many jurists have considered both as an asset and a liability of the common law system because it has often come in conflict with the fundamental doctrine of the separation of powers. So I predict that today's session will be rather enlightening, and I am certain that all of us are very eager to listen to Professor Reddy's lecture. However, before we proceed, I request the participants to please mute their mics and turn off their camera so that we can stream the webinar in a proper manner. And I also humbly request the participants to keep the questions relevant to the topic, and you are free to type in your questions at the chat box. Now, I deem it a great pleasure to invite Dr. Harita Devi, the Director of Research and Publications at the Tamil Nadu Dr. Ambedkar Law University, to give us all a warm and hearty welcome. Over to you, madam. You're muted.
No. Okay. Hope I'm audible now.
Yeah, you are audible.
Yes. Yeah. A happy welcome to one and all present here at the outset. A very pleasant good afternoon. I must first, before welcoming everybody, I congratulate Professor Dr. Revati ma'am for having taken up this program as a 1 week program, because we know how Herculean task it is to organize everything in a week. So at the outset, I welcome ma'am and I congratulate for this effort, ma'am. And today we have, as Ashwin has already pointed out, Professor Dr. G.B. Reddy sir, Professor of Law, Osmania University, Hyderabad. And he's actually not new to our institution, I think. We have met him already in some vivas and some boards. I first thank on behalf of the university for having taken up this time of presenting us this afternoon. Sir is a lawyer turned academician. He has done his BA, LLB and LLM at Osmania University and PG Diploma in Human Rights from University of Hyderabad. He obtained his PhD in law from Osmania University in 1999 on the topic Supreme Court and Judicial Activism, its contribution in specific areas of constitutional law after 1980. From there itself, today's topic is clear as to what is he going to speak. So we are very eager to hear that topic, sir. He has had a brilliant academic record with 3 gold medals in LLB and 1 medal in LLM. He has authored 20 well-received books on law, including Women in Law, IPR, Copyright, and so forth. In fact, that gives us that enthusiasm, and also seeing such profiles as a lecturer and as an associate professor. I feel that, okay, we must also start writing. Maybe that gives interest to the audience also, sir. That's so nice to see that. And he has published 56 articles on law published in standard national and international journals. He has worked as a principal, University College of Law and head Department of Law, Osmania University. And at present, he is the director, University Foreign Relations Office, Osmania University. He was the founder director of the legal cell at the university and worked in that capacity from March 2015 to August 2016. He was appointed as a member of General Council of Nalsar University of Law, Hyderabad for a brief period, and the Hyderabad District Legal Services Authority by the Government of Andhra Pradesh. He is a life member of the Indian Law Institute and the Institute of Constitutional Law and Parliamentary Studies, New Delhi, and the American Studies Research Center, Hyderabad. Participated in several national and international seminars, workshops, and conferences. He is a non-official visitor to Cherapalli Central Jail, member Telangana State Legal Services Authority, chairman Ethics Committee of CDFT Hyderabad, and member Academic Council of Nalsar University. He is also the chairperson of Board of Studies in Law, Osmania University at present. So in many capacities and many, I would say that his profile goes on and on, but we are all very eager to hear to that topic, judicial legislation. I also welcome all the professors and head of the departments who have joined us today. I welcome professors from other universities. Specific regards to Bismi ma'am, Bismi Gopalakrishnan ma'am, who has joined us and spared us her valuable time to join us. I welcome all the students who have taken that enthusiasm to take part in this 1 week long lecture series. I also welcome all the technical team and all the staff members, my colleagues and my dear students for this afternoon. Thank you for giving me this opportunity to Dr. Revati ma'am. Welcome you all. Welcome, sir. on behalf of the Ambedkar Law University.
Thank you so much, ma'am, for your warm words of welcome. And without any further delay, I would hand over the rostrum to Ms. Hariri to welcome our guest speaker.
Thank you, Ashwin. And thank you once again, Dr. Harita Devi, ma'am, for that lovely and warm welcome and letting us all know about Sir's achievements and contributions to the legal arena. Now, we have reached the moment we have eagerly been waiting for, the keynote lecture on judicial legislation, impacts and limitations. It is always uncertain as to where to draw the line between judicial activism and judicial overreach, and when the doctrine of separation of powers is violated and what constitutes complete justice, etc. I know we have so many questions in our minds regarding this topic. So without any further delay, let's begin with the session. It's my greatest honor to invite Dr. G.B. Reddy, sir, to deliver today's lecture. I humbly welcome you, sir, to take over the stage. Over to you, sir.
Thank you very much. Very good afternoon to all the learned colleagues. And I must thank Professor N.S. Santosh Kumar, sir, the Honorable Vice Chancellor, Professor Revati, and other learned colleagues in Tamil Nadu, Dr. Ambedkar Law University, Dr. Harita, Dr. Ashwin, Harini, and other distinguished faculty members among the audience, and Professor Bismi Gopal Krishnan, and many more. As pointed out by the learned faculty members just now, here is a topic of utmost relevance, and probably one can take many hours together to discuss and to deliberate on various aspects of judicial legislation. When I was doing my research, my guide, PhD supervisor, Professor Srinivas Rao, asked me, "You have chosen a topic that is judicial activism of the Supreme Court. But first you find out whether the judges discovered the law or made the law. Go to the roots. Try to trace the origins of the judicial lawmaking and try to justify the lawmaking and, in fact, the restriction not to make any law. Then ultimately you can, analyze what exactly is activism, so on and so forth." My topic is not judicial activism, you know very well. Only one species of judicial activism. Because if I say that judicial activism is the species and the judicial power and judicial review are the genus, I would say judicial legislation is a species of judicial activism. And today I think we have two very demarcated sections among the judiciary, the advocates, the legal fraternity, the legal academics, scholars, and others. One may welcome lawmaking by the judiciary with open arms. Other may say, "Your Lordships, there is a Lakshman Rekha, please don't cross, which is reserved for someone else." The judges, some of them might say, "No, in fact, you are not doing anything which you are supposed to do as mandated by the Constitution. You left a vacuum, so let us fill that vacuum." The other judges might say, "It is not our duty to make the law. Judicial legislation is a kind of oxymoron." If I may borrow the words from Kende Kaju, the learned, former judge of the Supreme Court. So these are the issues. But whatever may be the stand taken by the different protagonists of judicial activism or opponents of judicial activism, judicial legislation, and opponents thereof, the fact is that judicial legislation is a reality. And we are living with that reality. Question is this: if there is a doctrine of separation of powers, where we are expecting, or in fact, where we would be very happy to have the judicial, legislative, and executive powers in three separate watertight compartments, things would have been altogether different. But in modern times, especially during the last 3-4 centuries, we have seen that the concept of strict separation of powers has remained only a kind of utopian concept. And there is more breach than compliance. But that breach also is justified, either in the form of theory of checks and balances, or in the form of filling the existing vacuum, or in the form of, in fact, discharging constitutional obligations by the judiciary, whatever. But that line of difference between the three organs of the state has been slowly and gradually disappearing. And that is also a universal fact. I don't think we need to discuss much on that. But still, in spite of that, are there any clearly demarcated lines, LOC, line of control, which should not be transgressed either by the legislature or by the executive or, for that matter, even by the judiciary? Then we have to discuss about the judicial legislation. I was, in fact, going through some literature in order to update myself on this particular aspect. Because my work, research work on judicial activism mostly confined itself to 2 or 3 important areas like public interest litigation, then again the expansive interpretation of directive principles of state policy, then some kind of in fact institutionalization of new structures like collegium system, so on and so forth. About the judicial legislation, of course, I touched upon, but the focus was not much. I barely touched that particular issue, only to explain that here is the Lakshman Rekha. But that was almost, 22 years back in 1999. So here I am in 2021, and a lot of things have changed, theoretically and practically. So many new developments have come up, wherein we speak more about the judicial legislation than the legislation made by the legislatures proper. Fortunately and very unfortunately, I'm not apologetic here. I'm not, in fact, opposing the judicial legislation blindly or supporting it blindly. We will try to, analyze our stand from both the angles. And in fact, I had an occasion to go through a report or a paper submitted by someone in the 19th century, and incidentally the title was Judicial Legislation. He submitted that to Cornell University, and the title of the in fact paper is there such a thing as judicial legislation? The broad, in fact, the main title is Judicial Legislation. It was submitted for the degree of Bachelor of Laws by one Frank Bowman to Cornell University School of Law, and Hold Your Breath, 1893. That means almost 125 years before. And there, the learned graduate starts with certain provocative statements. He quotes Lord Mansfield as saying that it is not my duty to make the law, but by my industry, I can find out what the law has been in the past and thus declare it for the future. So, Lord Mansfield was a supporter of the declaratory theory. So, it is not my duty to make the law. This is one important aspect. And there, another important point also, just one more statement, then I'll come back. Question is whether the courts are meant only for judging, as to whether a particular question is found previously considered and determined with due deliberation, and whether such due deliberation is the test as to whether it is good or bad law. And if bad law, it is no law at all. Those were the days. And I also had the good fortune of going through an article published by one of your eminent academicians associated with Tamil Nadu Dr. Ambedkar Law University in the year 2005. Professor Raghunatha Reddy sir also published a very good article in Journal of Indian Law Institute. And it was a pleasure to read this. You can also go through Legal Reforms through Judicial Lawmaking, a critical appraisal from Roman law to common law. Very wonderful, title, where Sir tried to trace the concept of judicial lawmaking from different dimensions, right from Aristotle, then Dworkin, then, these two persons, always opposed the concept of judicial lawmaking. And from there, Sir has traveled, a long journey to the present day. I will stop my reference there. It is over to the, in fact, learned audience to go through this in 47 Journal of Indian Law Institute, 2005 at page 469, available, because I asked one of my students to download and he got a printout. This is a printout. I have it with me, and I will stop my reference here, but you have a piece if you go through it. This is another important aspect. Whatever may be the case, the point is, judicial legislation, as I already mentioned, or judicial lawmaking is a reality today. Reasons are many. Because we are looking more at the judge-made law. Judge-made law has become the most accepted norm in modern times. This is one important aspect. And in fact, I may quote Justice P.M. Bhagwati. Maybe he was one of the earliest judges who was the supporter of judicial lawmaking. And on judicial activism in India, while speaking about this, he says that it is here that the judge takes part in the process of lawmaking. Lawmaking is an inherent and inevitable part of the judicial process. So to judges like Justice P.M. Bhagwati, lawmaking is an inherent and inevitable part of the judicial process. So, and he mentioned it, long time back, maybe almost 20, 25 years back. This is one important point. Then, in fact, there is one more very interesting observation made by a legal scholar. He says that judicial lawmaking is recognized by the Constitution itself. And he went to the extent of referring to Article 13, Clause 2. And when you talk about the definition of law, right, then he says, there is a mention about other competent authority. Other competent authority apart from the legislature. What is that other competent authority? He says implicitly it includes judiciary also. Other competent authority need not be the state. Other competent authority, that's what they mention. Whether judiciary is state or not, is very well known today. Because for certain purposes, it may be a state under Article 12, for certain other purposes, especially for the judicial, functioning, probably it's not state. That's a different issue. But under Article 13, he, very interestingly quoted this particular aspect. Laws in force, especially, other the pre-constitutional laws, which may extend even to the, present lawmaking, laws passed by or made by a legislature or other competent authority in the territory of India. Of course, that is before the commencement of Constitution. You can also extend it to the post-constitutional laws. That's what I think Mohit Sharma says in one of his, published articles. Like, what is that Lakshman Rekha? Very interestingly titled, right? So, judicial legislation, what's the Lakshman Rekha? So, this is also available, recently published, almost, about 6 months back. This is another important issue. Anyway, Here, the point is whether judicial legislation must be supported or opposed. Because, as I already mentioned in the beginning, we have two well drawn, drawn out groups, one which supports, one which opposes. There are activist judges who support. There are restraintivist judges or conservative judges who oppose. I give you an example. One could be P.N. Bhagwati, who may support. Justice V.R. Krishna may support. Right? And many others like Justice R.S. Pathak also may support. There are also opponents of judicial legislation, including, Justice Markandeya Kaju, and many more. In fact, in England, you come across, wide array of, in fact, there is a long list of laws who oppose judicial legislation. And in fact, it is relevant to mention what Justice Krishna has said about the judicial lawmaking in one of his, books. He says, judge is not a mimic. The greatness of the bench lies in creativity. It is for this reason that when a law comes before a judge, he has to invest it with meaning and content. But there comes the justification. He says that to meet the needs of the society, the judges do make law. Why do judges make the law? To meet the needs of the society, and it is now recognized everywhere that judges take part in this law-making function. Therefore, judges make the law. Very emphatic statement made by, Justice V.R. Krishna here. And again, the question is again whether it is boon or bane. Somebody was writing on Justice Krishna here. He was quoted in the above terms. This is a very important point. And you find that in the United States of America also, judicial legislation is not something unheard of. Today, anyone who talks about judicial review must always remember that this concept was never envisaged anywhere in any law. Neither the Constitution of United States of America 1787 itself, nor the Judiciary Act, which was invoked to approach the Supreme Court. William Marbury approached the Supreme Court. Justice John Marshall went to the extent of carving out a power for the judges of the Supreme Court and federal courts, saying that law is what the judges say it is. It is emphatically duty and province of the judges to say what the law is. Ultimately, it was nothing but judicial legislation. That is one of the finest examples of judicial lawmaking. And it has not been overruled anywhere, to the best of my knowledge, at least in democratic constitutions or democratic worlds. This is a very important aspect, friends. Then, question is this: we don't expect the judges today to confine themselves only to determination of cases and controversies. The expression cases and controversies is used in the American Constitution. You know that. The judges do go beyond the cases and controversies. They try to not only interpret the law, not only apply the law, sometimes make the law. And they don't discourage any kind of judicial lawmaking in the form of judicial interpretation. Because, you ask Justice Deepak Mishra about what is constitutional morality, the constitutional, transformative constitutionalism, constitutional ethics. In Manoj Nariman's case, on the first reading, every reader gets confused what the young judge is trying to say. But over a period of time, you will try to find out the distinction between all these aspects. And I had a very good opportunity to speak to Justice G.R. Swaminathan from Madurai bench of Madras High Court, who was also, one of the speakers, key speaker, in fact, in a national seminar on transformative constitutionalism. There we were trying to discuss the subtle difference between these, like, what is judicial activism, what is judicial legislation, what is, judicial ethics, morality, so on and so forth. Here also it's the same thing. In the name of judicial interpretation, judicial legislation is most commonly resorted to. This is another emphatic statement which I would like to make. Because the judges have the flexibility of, in fact, using this tool of judicial interpretation to make the law. So to come up with the judge-made law, this is one important aspect. Whatever everybody does indulge in judicial lawmaking in the name of constitution only. They don't do it on their own. What I am doing is only to uphold the constitutional morality, only to, in fact, to fulfill the constitutional mandate, only to take care of the, in fact, the needs of the society, which are left unattended by the other organs of the state. I think Abraham was one of the very keen commentators on the political role played by the judges in the United States of America. He always said, political role by the judiciary. Their judicial activism for many Americans, it's nothing but the political role played by the judiciary. Political role means the role played by the political organs of the state, legislature and executive. And what is the primary function of the legislature? To make the law. Now, when the law is not made, or when it is inadequate, then comes the judge and with a particular set of guidelines. Sometimes a policy, sometimes a concept which is not heard of in any annals of the history. Somebody said, what is judicial legislation? I asked one of my students, he said, sir, nota. Nota is a result of judicial legislation. None of the above. And then I said, fine, you try to, download Representation of People's Act 1950 as well as 51, then control F, search for none of the above or nota. Do you find nota anywhere? No way. Try to find the expression in the Constitution itself. Nowhere. Then how come in the ballot paper, nota comes today? I'm sure that most of you are voting. Nota is one of the candidates there, none of the above. Judicial legislation, which has been recognized and enforced by the, in fact, the government also, election commission also. This is one more important aspect. So when we are talking about the jurisprudence of judge-made law, as I already said, in fact, when you look at the classical positivist jurisprudence, as propounded by Bentham, Austin, and many more, they always condemned judge-made law. Even in the Greek philosophy, ancient Greece also, for example, Aristotle, he said, emperor has a discretion, judges don't have discretion. Emperor has a discretion. Ultimately, they wanted the ruling class, the kings to have the sovereign to have the discretion, but not the judges. Judges can't make the law. Same is the case with Austinian, view, saying that they cannot do anything like judge-made law. That is one aspect. Then, in the 20th century, when you look at the writings of Hart, Pilsen, and others, then, even though they recognize that lawmaking is the responsibility of the legislature and not the judiciary, but the interpretation part has been recognized by them. So to infuse life into drivers of legislation, certainly, you can accept the fact that judges do interpret. But the enforcement of such interpretation was also a question. Even sociological jurisprudence, for example, when you look at, Roscoe Pound, in fact, he says that Roscoe Pound not only, the propounder of the sociological jurisprudence in USA, even the realist school also ultimately realized the lawmaking. Just remember Oliver Wendell Holmes Jr. And he says that life of the law is not logic, but experience, the felt necessities of the society and all. So ultimately, the activist judges relied upon this particular, foundation to come up with judicial legislation. This is one, right? And I will just, make one more reference to jurisprudence, then I'll come to number of judgments where we have seen judicial legislation. We try to analyze what exactly has been their impact and the limitations. When you, in fact, come to one of the founders of the realist school, Gray, he observed once, he said that it has sometimes been said that law is composed of two parts, legislative law and judge-made law. But in truth, all the law is judge-made law. Beautiful statement. Maybe a very realistic statement also, made by a proponent of realist school. The law is composed of two parts, legislative law and judge-made law, but all the law is judge-made law. This is another important aspect. So others also, they try to support this particular view. Question is between two things. One is deductive theory, the other one is inductive theory. Right? So declaratory theory is the crux of the issue, and whether the judges only declare the law, or discover the law, or find the law, or make the law, these are the questions. And now we are saying that judges do make the law, no question about it. Any number of examples to be given. So before that, I would like to touch upon the factors which may justify the judicial legislation. Why the judges indulge in lawmaking? For example, one reason could be that parliamentary inability to meet the vision envisaged by framers of the Constitution. Parliament, the Union Legislature, then state legislatures, when they have a mandate to discharge their legislative functions, to make the necessary laws in tune with the changing times and needs of the society. And when they fail to do so, judges may feel that, we are not lagging behind. When the parliament fails, we can do something. Whether interstitially, regularly, or otherwise, that's a different issue. That is one reason. Then another reason could be relatively shorter sessions of the parliament. This looks like a very simple reason. But our parliament, our legislatures meet, we are supposed to meet twice in a year without, exceeding 6 months gap as per the Constitution. But when they meet, I have not come across, at least in recent times, any, important bill or proposal law being discussed for days together in depth. That is to understand the needs of the, in fact, the society. So they are always in a hurry. They make laws which are, for example, take the case of the recent regulation relating to the tribunals, the rationalization of tribunals. Many of the tribunals are abolished, is it not? And look at the kind of drafting. One of the objectives is to regulate the appointment of chairman, chairperson. Why chairman, why chairperson? Do you expect this from the parliament? From the legislative drafters? This is the problem. So when such is the state of affairs, judges think that they are better. Very unfortunately, this kind of exercise induced by the judges themselves in the instant case. That's the reason why. In fact, I tried to make a critical comment, which was published in, I think, Bench and Bar and Bench, where it is tribunalization or trivialization. Tribunalization or trivialization. But point is that the law says, notwithstanding any judgment declared given by the Supreme Court, notwithstanding anything declared by the Supreme Court or directed by the Supreme Court. So non-obstante clauses are used now by the legislature to withstand the challenge of judicial legislation. I am going to that, a little late from now. Then similarly, splintered composition of the legislatures. When there is a stable government, probably judicial legislation is almost, not seen, unheard of. But when there are weaker governments, you expect the judiciary to, in fact, fill that legislative vacuum. absence of effective opposition, then the executive is too preoccupied with the security matters, policy matters, and they have little time to concentrate on the finer aspects of legislation. That's a real problem. Then the judiciary definitely steps into the picture and tries to do something. Then another one also, in fact, in one of the old articles published sometime in 1977, Bernard Horowitz, the title is The Courts and Social Policy. He says one of the reasons for judicial legislation is absence of exogenous political forces in the rigorous judicial test of relevance makes it more responsive than the other two branches.
Sir, can you explain? Actually, your voice is getting increasingly disturbing, sir. I think there's some problem with your. So yeah, yes, sir.
Mic or distance?
There's some sort of disturbance when you're speaking.
Fan. I'll switch off my fan. Just a second. Let me see.
Okay.
Is it okay? Better?
I think so. I think it'll be better if you could use a headphone or a earphone, something like that.
Very unfortunately, I have nothing, but I'll be nearer to the screen. Let me see. I'm going to headphones now, as of now. Okay.
Sure, sir. No problem.
Fine. I think I'm audible now. Clear?
Yeah, you're audible.
Sometimes it's okay. Voice may be tailing off. Well, these are the technical problems, but anyway, I should have brought my headphones. Well, I'm trying to draw your attention to the absence of the political forces and rigorous judicial tests. What happens? The level playing field will be missing. The field is wide open to the judges, so they can come out with their own kind of judicial legislation. The problem still exists.
Well, sir, it is a bit your voice is very disturbed.
Okay. Yeah. So maybe now it will be better. Now, then another important point. Under what provision of the Constitution judges indulge themselves in judicial legislation? And very fortunately for the judges, there are a number of provisions, not one but many. But one of the most common provisions of the Constitution, which is invoked by the active judges or supporters of judicial legislation, is Article 142. You have the concept of complete justice. I think it is Ms. Arvind mentioned that in the beginning. Complete justice. What is this complete justice? So Article 142 has been invoked any number of times in the name of doing complete justice to the orders given by the courts from time to time, or in implementing them or enforcing them. Unity petition also is one of the results of Article 142. This is one aspect. And as I already mentioned, there are arguments for judicial legislation. For example, somebody says that courts are now court of good governance. So good governance is coming from the courts, not from the government. And that is also something debatable. Then recently, about 5 years back, Justice Kurian Joseph of Supreme Court of India, he says that the judges can certainly interpret a law, but they should not create a law on their own and seek to enforce it at all. Maybe he is in association with Justice Markandeya Kaji. So this is one aspect. Some of the judges feel that way, but other judges think that actually, we can do anything in the name of judicial legislation. And another important point, somewhere a question is asked, whether the judges have done anything wrong by resorting to judicial legislation for welfare of the society, right? The answer seems to be no. This is another important point. And another justification rather is that when you talk about law and justice, please remember that law includes justice also. So for the sake of ensuring justice, law can be made, therefore judges make law. This is also another important aspect. But when you look at arguments against judicial legislation, I already mentioned what judges like Justice Kurian Joseph said, but I will also draw your attention to Justice Markandeya Kaju. And he says that judicial activism requires reconsideration for it entails unpredictability in the law apart from violating the principle of separation of powers. It entitles each judge to lay down the law according to his own subjective notions. This is the criticism, not objective notions, subjective notions. Here I will draw your attention to, in the judicial academies, this question comes up. Why a person who is only a graduate, just a fresh graduate, is in a position to become a junior civil judge today? Why not 3 years minimum experience, as was the position before? Then somebody offered an answer. Maybe someone who is very close to the judge who laid down this particular, ratio in one of the judgments did not have 3 years experience. The net result is that the entire nation got benefited. But when you go to the courts, you will come across a very sorry state of affairs because most of the fresh junior civil judges or judges may not be having sufficient exposure to the practical aspects. But the entire system of appointments have changed. Point is, that is the subjective satisfaction of the judges, whether it was objective, whether it has resulted in fact, achieving the objective of such fresh appointments. That is $1 million question. And here, as I already mentioned, Justice Markandeya Kaju says, in our view, judicial legislation is an oxymoron, self-contradictory. Judicial and legislation. You don't expect legislation to be made by the judiciary. Then there are any number of case laws, judgments, dear friends. I think that is our advantage. And here we come across, take for instance, I will take you through almost 20 to 25 judgments without going into what the judges said actually. My observation will be only limited to what the judges have done, how it has been accepted or rejected by the political organs of the state and also the, ordinary citizens. We can start with Lakshmikant Pandey versus Union of India, 1984. We are going to the last century. You know the importance of this case. Those were the days when foreigners used to adopt Indian children, and there was nothing like CARA, Central Adoption Resource Agency, which is existing today. And ultimately, the Supreme Court took upon itself the task of issuing guidelines regarding the adoption of Indian children by foreigners. It has become an accepted norm today. And in fact, the structures which have come up subsequently, they are in fact in pursuance of the judicial legislation, not only in pursuance of the Guardians and Wards Act, not only in pursuance of the Juvenile Justice Act. These are all subsequent developments. Is it not? So, a home for the child and a child for the home, gone are those days now. This is one important case. Probably here the impact has been tremendous. And the concept of child trafficking in the name of international adoptions to a great extent has come down. After this may be in the positive direction. This is one. Second one, probably if you come across the judicial legislation more frequently, that is in the area of environmental protection. Whether it is MC Mehta or Grievance Litigation and Entitlement Kendra and many more. And of course, there are certain limits. I will quote Mr. Arun Shauri, who wrote that wonderful book, Courts and Their Judgments, as to the impact of some of the judgments which may have laid down judicial guidelines and made judicial legislation. But if you look at 1985 judgments of R&D Kendra, Dehradun versus State of UP, certainly the quarrying operations in Uttar Pradesh and the other time Dehradun, all of them were there, right? In the same United Uttar Pradesh. And they came to a halt because of the activist approach, because of the guidelines given by the judges. Of course, in Bandiya Morcha versus Union of India, from 1984, when certain guidelines were given for freeing the bonded labor in some of the northern states, working in mines and quarries, etc. Even though judges like Justice P.M. Bhagwati gave number of directions, number of guidelines to the governments, they did not oblige. Many of them failed to have the desired effect. Then ultimately they gave the guidelines to the learned high courts. Chief justices were entrusted with the task of implementing them. Nothing happened. Mr. Shawri says that from 1984 to 2001 or 2, for almost 17 and 18 years, most of the child labor were not freed. On the contrary, the supporters of abolition of child labor and bonded labor got accused of even committing murder cases. Criminal cases were booked against people like Swami Agnivesh. What I am trying to say is that judicial legislation has got its own inherent weaknesses, especially in the context of implementation of those guidelines. The set of guidelines laid down. Then I will come to another case. MC Mehta, any number of judgments. Honestly speaking, MC Mehta has been very successful, either in getting some of the polluting industries closed, or shifting them from, the Agra to distant places. Retrenchment compensation was sought to be awarded. You remember? And that is okay. And even he also succeeded in another case. Today, the directions, what should be taught in the schools regarding the environmental education and all, it is not the concern of the judges. In the oil and gas leakage case, that is Sriram Fertilizers case, filed by MC Mehta, ultimately they said that, teaching of lessons on environmental protection of natural environment, all of them should be taken up. I think that doing now. Not that things have changed drastically in the positive direction, but that is also kind of judicial legislation. You must have heard about CBI being called the caged parrot. CBI, Central Bureau of Investigation, has been described as a caged parrot, and that was probably Mini Narayan versus Union of India, 1997, Jain Hawara Dairies case. Like the way the appointment of CBI Chief Enforcement Directorate, Central Vigilance Commission, in fact, detailed guidelines were given by the Supreme Court in this Mini Narayan versus Union of India. You may recollect, the facts were that the editor of Kal Chakra, in fact, he was the person who was responsible for this. And the judiciary responded in kind. Those guidelines are still referred to with regard to the appointment. Not that all of them are really followed. With regard to police, another set of guidelines came up in Prakash Singh case. Right? This is one. Then another important point. In India, many persons misuse the caste certificates by obtaining false caste certificates, fake caste certificates. And the governments of the day mostly failed to arrest that particular trend. Reason being that there are political overtones. So, if a fake scheduled caste or scheduled tribe certificate is obtained by a non-scheduled caste and non-scheduled tribe, are there any sufficient guidelines, in fact, present or followed by the respective state governments is the question. This issue was addressed by the Supreme Court in another case called Margaret Patil versus Commissioner, Tribal Department, 1994. And who should streamline the misuse of caste certificates? It is the government job. Whether it is the primary law or secondary law, legislation, it should be resorted to by the legislature and the government respectively. But instead, it is the Supreme Court which ultimately invoked its power and laid down the guidelines for issuance of caste certificates to scheduled castes and scheduled tribes. This is one. Today we are talking about right to care, protection of public health, especially during pandemic. Of course, that is another important issue. I think the judiciary has resorted to, lot of, in fact, lawmaking, especially during the COVID period. In fact, whether it is release of many of the prisoners on parole, right? And some of them came back, again they were sent back. Recently we are seeing efforts towards decongestion of jails by releasing those persons. But this is purely based on the guidelines given by the courts, not given by the government. The government issued GOs to implement those guidelines. Recent one, 2021 also. This is another important aspect. Then we have coastal zone regulations. Recently we have seen Manadu, flats abolition in Kerala, which were built based on the prior permission given by the Gram Panchayat there. Thereafter, the conflict arose between the Pollution Control Board and other local bodies. The matter went up to Supreme Court. Supreme Court says, yes, Jagannath versus Union of India, the 2005 judgment, right? 1996 judgment. That is the ultimate, benchmark with regard to implementation of the coastal zone regulations. There cannot be any construction of resorts or villas or residential structures in this particular coastal zone. And we have coastal zone regulations already enacted, but the courts, especially the Supreme Court, added something more to that to make them more effective. Then another important issue. In the same environmental protection aspect, we always speak about a conflict between anthropocentrism and ecocentrism. And very unfortunately, many of the successive governments, barring people like Maneka Gandhi, or Jawaharlal Nehru to some extent, and I'm taking these names with respect because of their work, which they have done in their capacity as ministers and all activists. Majority of them focus only on anthropocentrism. Man is the, in the master of universe. Everything is for the man only. But in P.N. Godavarman case, not one case, there are 3 cases. And also there are, other related judgments relating to Wildlife Protection Act and all. The Supreme Court ultimately relied upon CITES Convention, CITES. You remember that is, a convention on international trade in endangered species, CITES Convention, to which India is a party. So sandalwood and many other, in fact, endangered plants also come within the meaning of this CITES Convention. Endangered species, don't think that it's only animals, but plants also will be covered, including red sanders. There also guidelines have been laid down. And the Supreme Court took upon itself this responsibility of laying down the well-drafted guidelines. These are very important aspects. But maybe the best excuse for judicial legislation comes in the form of Vishaka guidelines. Vishaka guidelines. Even today, people, in fact, they are not worried about 2013 Act. Many of them don't even know the complete, name of the Act, title of the Act. They say Poach Act, right? That is, Prevention of Sexual Harassment Act, very easy, rehabilitation, etc. All of them are missing. Point is very simple. In Vishaka versus State of Rajasthan, whatever have been the guidelines, laid in the year 1997, they occupied the field till 2013. But almost close to 16 years. And here there was an emphatic statement in the judgment itself. The learned judges said, these guidelines which are made by us in accordance with the CEDA, Convention on Elimination of Discrimination of All Forms Against Women, they will continue to be having the force of law until the Parliament enacts the necessary law. This also explains why the judicial legislation, at least in few cases, must be supported. Because we have seen that in spite of having umpteen number of laws, whether it is Indian Penal Code or Indecent Declaration of Women, Prohibition Act, and many more, where is the protection to women, especially at workplace? Because workplace sexual harassment is something of, in fact, a different kind of harassment. IBC may not really, offer all the answers. Outraging the modesty of women will not be the only solution, or insulting the women will not be the only solution. So the guidelines have been laid down, and all those guidelines have become chapters. They have been followed by the central government offices, state government offices, and it is very gratifying to know that the same guidelines became the basis for the amendment of the Indian Penal Code in 2013, post Nirbhaya, then enactment of the special law relating to harassment of the working women and the remedies therefore, right? And then this is the, in fact, the judicial, legislation in the best sense. This is one important aspect. Then, of course, about the deforestation across the country. Kamal Nath's case come to our mind, right? And again, the concept of anthropocentrism versus ecocentrism. The Supreme Court tried to, in fact, enact guidelines, lay down guidelines, relying upon the fundamental duties, maybe Article 51 AG and all. And that is the beauty of it. Maybe today, I think this area is fertile area of judicial legislation. Not only this, friends, I also, in fact, Samaj Parivartan Samudaya was the state of Karnataka. You must have come across number of cases and under this caption, Samaj Parivartan Samudaya. It's all about the mining operations in Karnataka, in Rajasthan, Goa, and many other states. The point is very simple. How the Supreme Court has directed the constitution of an empowered committee. EC, that's what they say. Normally, if I want to do mining, you want to do mining, you will go to the authorities under the Mining, Mines and Minerals Act. But here, we have to get permission all the way from the, empowered committee. No objection kind of thing has to be obtained from the highly empowered committee. And this is what is the contribution of judiciary in the context of the judicial legislation. Another one. About judicial activism, India is a very happy place where the people are, Justice H.R. Khanna also said during his heydays, that India is a rights conscious nation. We are worried only about our rights. We don't care whether others are dying when we are exercising our rights. Duties are forgotten long time back. I wish that the situation is altogether different. Be that as it may, smoking in public places. And people used to smoke in public places like rail engines, right? Coal engines. And they are unmindful of the negative impact the smoke has on the non-smokers or passive smokers. And whether it was public places or even private places. Then came the judgment in Murli Devara case, I think 2001. Murli S. Devara versus Union of India. It was a Congress MP, but still filed the appeal. Ultimately, he wanted Section 133 of CRPC to be invoked to curtail smoking in public places, which is injurious to health. Everyone reads that slogan, but never, puts it into practice. And Supreme Court declared that the smoking in public places is a crime. It attracts not only the provisions of CRPC, but it must also be punished. And what did the Supreme Court do? The government do? It waited up to almost 6 years, or 7 years rather. Then on following morning, they issued guidelines, again in tune with what the Supreme Court said. Point is very simple. The Health Ministry and other ministries should have come out with a clear plan regarding curbing of public smoking in public places. And if the Supreme Court issues some guidelines prohibiting the same, certainly one has to welcome it. Why? You failed, therefore I am acting. As simple as that. Let's not go into the jurisprudential aspects. Like, because whether I can make or not. But I can't remain a silent spectator, especially in the 20th and 21st century if I'm a judge. I feel that the Constitution imposes obligation not only on the legislature and executive, but also on the judges. Not for, in fact, glorifying themselves, not for self-aggrandizement, but for achieving a social purpose. This is another important aspect. Then, for example, in the noise pollution case, this is also one of the interesting cases, which was a suo motu taken up petition by the Supreme Court, based on a news item published in daily newspapers. Simply, a young girl was raped in a house. Her cries for help did not reach anyone because of a lot of commotion, music, etc., which was being witnessed or taken up in the adjacent house, shadi, and so much celebration, so much noise, loudspeakers. What happens? The young girl became a victim. And then many people do not know that under the Environmental Protection Act 1986, how many guidelines, how many regulations are made, God knows. Whether it is leads to management, whether it is noise pollution related or air pollution related, whatever it is. And there are guidelines in their place. But still, they were not implemented. The Supreme Court says these are the silent zones. So this is the limitation of the sound limit. How many hertz, right? And use of loudspeakers must be curbed between 10 p.m. and 6 a.m. If it is an emergency, these are the guidelines to be followed. Very unfortunately, our CRPC doesn't mention about these timings and all. Ultimately, they are left to the discretion of the officials. This is also another good instance of the in fact judicial legislation. Then about the appointment of the Director Generals of Police, that became a contentious issue. If I'm not mistaken, one Mr. Dinakaran, who was the DGP of Karnataka, he himself became an advocate in these matters because he was one of the victims in the so-called supersession. Don't think that only judges are superseded. Sometimes seniors are also superseded like this. And ultimately, in one particular case, in 2006, Prakash Singh versus Union of India, where in fact, the Supreme Court came out with number of guidelines. It looks like a chapter of guidelines, like how the police recruitment should take place, then how police commission, security commission should be appointed, so on and so forth. Because Prakash Singh was a highly placed, retired police official those days. This is also, in fact, a kind of judicial legislation. We have many more. I'll touch upon two of them. For example, Nora, I mentioned just now. None of the above. People may ask us, who is this Nora? Is he a candidate who is contesting everywhere? Because Nora is printed on the ballot paper, is it not? It was not initiated by anyone. Because the dissent of the people, the voters, must be recognized. Their right to protest has to be recognized. Therefore, the Supreme Court in 2013 in PUCL versus Union of India directed the Election Commission of India to have this nota as one of the options. It is for the candidates. In fact, the voters who say that nota, they are not favoring any of the voters. Candidates are contesting candidates. This is another important issue. So red beacons, that is another issue. Every person, because you see, practically speaking, while wearing a car with red beacon always gives you the feeling of being a very, very important person, right? Like, when you are traveling with a High Court judge or Supreme Court judge, so red beacon comes. Question is, even ordinary mortals, others who may not have so much urgent work or priority, they also start using. What happens? There will be a chaotic situation. In this country with unnecessary VIP culture, this use of red beacons indiscriminately by those deserving and not so deserving. Ultimately, it was addressed by the Supreme Court in Abhay Singh's case. Another one. But here I would pause for a while to discuss certain aspects of ascertaining whether a certain direction, certain declaration always amounts to judicial legislation, because former cabinet secretary Mr. T.S.R. Subramanian, he filed a case sometime in 2013 before the Supreme Court. His argument was twofold. One, normally no transfer of an official should be effected, especially under the civil service rules, before such an officer completes 3 years of service. Second one is that no public servant should act only based on the oral directions given by the superiors, including political masters. Honestly speaking, both of them are covered in our fundamental rules, conduct rules. So, what the Supreme Court said in case of Subramanian, it only reinforces what is contained in the service rules. You can't say that it's a judicial legislation. Right? It is only, in fact, the reassertion, recognition, right? Re-emphasizing on the rule position by the judiciary. So we should be in a position to distinguish these aspects. Then another case, for example, Lily Thomas, remember, she was a highly respected women advocate in the Supreme Court. And Lily Thomas was trying for almost 10 years in order to make her voice heard before the Supreme Court under the Representation of People's Act, about the criminalization of politics, about Section 8 of the RP Act. The question is, before that, before she interfered and in fact, the stand was recognized and her matter was heard by the two-judge bench of the Supreme Court, the position was that the only person who was convicted for 2 or more years was given 3 months' time to appeal. Many persons used to make use of this 3 months' time and the appeal, and by the time they used to get some kind of suspension of sentence, conviction, so on and so forth. Then the Supreme Court, taking a leaf out of the judgment in Lily Thomas versus Union of India 2013, ultimately went on to say that the disqualification is instantaneous. There is no waiting period for disqualification today. No 3 months period and all. What I am trying to say is that what the court said is nothing but kind of revising or amending the, in fact, Representation of People's Act in order to, make it more effective. That's another issue. And I can also draw your attention to, regarding the elections, another very interesting case, Association for Democratic Reforms versus Union of India. Filing of affidavits by the candidates who are contesting in the elections regarding their education qualifications, regarding the assets of themselves, their family, right? Any criminal cases pending. So you can recollect how people questioned about the qualifications of Rahul Gandhi, Sonia Gandhi, Smriti Irani, many more. Right? Not that education qualifications really make any difference on Indian voters. Right? Education qualification, even if a person with 100 degrees contests, I'm very sure that he will lose his deposit. But the other aspects, like the tendency of criminal cases, right? And similarly, the declaration of assets in the form of an affidavit. This was not there in the Representation of People's Act. It is the Supreme Court in Association for Democratic Reforms versus Union of India that ultimately, such declaration was made mandatory. Funny thing was that all the political parties again came together. They wanted a review of the commission, right? And Justice P. Venkataraman was there at that time in the Supreme Court, and ultimately they sought to, in fact, amend the law, saying that notwithstanding anything contained in any judgment, just now I mentioned about tribunals, Supreme Court struck down that, right? Maybe it is like that. Nobody questions the judicial legislation as judicial over-activism here. This is another one. Then we have Nalsa judgment. Judicial legislation has certain limitations. I'm talking about the National Legal Service Authority versus Union of India 2013. Everybody empathizes with the, Yogyakarta principles, the plight of LGBTs, the plight of, by whichever name they are called, third gender and so on. Supreme Court also sympathized, empathized, and they wanted them to be treated as backward classes. Low thinking. What kind of backward class? Question will come, is it not? So, should they be treated as B, C, A, B, C, D, E? Right? Whether creamy layer, non-creamy layer. Point is, sometimes in their, quest for doing something good for the neglected sections, the courts also go overboard. So that becomes only armchair activism. Sitting in the AC rooms and declaring that so-and-so is right, so-and-so is wrong, so-and-so are the guidelines. They must be practical. Then only, I think, there will be enough respect from the concerned stakeholders. So that is Nalsa judgment. Today, of course, you have the Transgenders Protection Act. I mean, there are many more initiatives thereafter, especially in Kerala, in the matter of employment. Then acid attacks. We have seen how acid is sold in the open market and how there are no regulations relating to the restrictions on the sale of acid. For what purpose? Lack of maintenance of data. The details of the persons who are buying, the purpose for which they are buying. Then comes Lakshmi's case, Lakshmi versus Union of India 2014. So the Supreme Court came out with the guidelines. Of course, you also have 326A and B in the Indian Penal Code, but this will supplement. This is one. Then there are other important aspects, like take the case of course, it is not the law making, the guidelines were there. You tell me, which law in India says that when cinema theater, we enter the cinema theater, movie is about to begin, and ultimately national anthem, please. I think our parents used to say that in the good old days, that was the practice. Got discontinued for a long time. Then, like a national anthem case of 1980s, which was ultimately put in court story by Justice Chinnappa Reddy in Supreme Court in 1980s, 85 or 86. Remember, they say that freedom of speech includes freedom of silence. Then comes Shyam Narayan Chokse's case, right? The retired civil servant, a very stubborn person. Ultimately, he filed a case in Madhya Pradesh when the Madhya Pradesh High Court ultimately refused to say that the first fundamental duty cannot be directed to be followed in letter and spirit. In Kabhi Khushi, Kabhi Gham, the so-called national, anthem, scene should be, repealed. Ultimately, it was repealed. You remember? This is one more aspect. Just a second. Phone just a minute. Phone sir, online class from I think yes. I'll get back to her. Thanks. Yeah. So ultimately, and the anonymous petitioner took up the matter by way of an appeal to the Supreme Court because Madhya Pradesh High Court found a very convenient way out. What they said is we cannot direct all the audience to stand up respectfully while the national anthem is played. Best thing is to remove that scene from the picture itself. They directed the censor board to remove it. But against that event, and up to in 2016, Justice Deepak Mishra ultimately held that, in fact, constitutional patriotism demands that every Indian citizen must respect national anthem, national flag, and 51A, at a small A, right? Point is, this is a kind of legislation also. You don't find it anywhere. That, even in cinema theaters, you must stand up. Again, you must give this credit to, the judiciary itself. Then there are, a few more cases. For example, take the case of living will. Living will, can we, what is living will? I think many of us know. So we'll decide how long we are going to live, when are we going to die, right? So some kind of, this is recognized again, no law permits this, neither the Indian Succession Act nor any other law of 100 matter. Because I'm referring to Indian Succession Act because the will is taken care of by, this particular act. But in Common Cause versus Union of India 2018, the Supreme Court ultimately came out with certain guidelines regarding the, living will. And in Arunachal also, there was passive euthanasia, which was recognized. Now, this may be in continuation of that. Then, regarding honor killings, Shakti Vahini case, you know very well, and whether honor killings must be made special offences under Indian Penal Code, whether we should come out with a separate legislation itself, guidelines are issued. And in fact, I think in Lata this Shakti Vahini and many more cases, the Supreme Court also was very particular that such practice should be discouraged and prevented. Governments are acting on that. Case in Poonawalla case, remember? Case in Poonawalla versus Union of India. Lynching, mob lynching was the issue. And mob lynching is not mentioned anywhere. Please try to understand. This is a concept which is emerging now. Since the legislature has not paid its attention to the concept of mob lynching, they are trying to, in fact, address this particular issue through the judicial guidelines. School-going kids, whether we should burn firecrackers during Deepavali or not is the issue. Is Deepavali a festival of lights and festival of sounds is the issue? Supreme Court categorically mentioned it is only festival of lights, not festival of sounds. Then, in spite of having such a well-founded jurisprudence or precedents, again the governments of the day they started permitting. And in Arjun Gopal versus Union of India, 2 school-going kids for the petitioners. Again, the point I am trying to highlight is that there is a judicial inconsistency in the matter of judicial legislation also. Like 1 step forward, 2 steps backward in many cases. So if you restrict the burning of crackers, you better restrict. Again, you can't relax. Sometimes the relaxations, they dominate the real restriction. Same thing happened in the case of Arjun Gopal versus Union of India. Initially, it was a very lauded set of directions in 2019, but in 2020 it was something else. Relaxations were given. Then there are many more. CCTV cameras in all the police stations, this is one. And we have many more such judgments, maybe 1 or 2 I will discuss, then I will stop. How much time do you have? Please, Mr. Ashwin, how much more time do you have?
Yes, sir. We have time till 4:30.
Till 4:30?
Yes, sir.
So there is another 5-6 minutes?
Yes, sir.
Okay, fine. If that's the case, then another point, the appointment of judges by the president through collegial system itself is a kind of judicial legislation, is it not? What the second judges transfer, case said in 1993, what the presidential reference reiterated in 1998, right? And what was struck down, that is the Article 124 A, B, C, and the amendment made to Article 124 by the 99th Amendment. Ultimately, everything is judicial legislation. Probably this is something which is not appreciated by many, including some of the judges. So, Justice Jafri Chandrashwar, for example, you asking, he was the dissenting judge in 2015 judgment, which struck down 99th Constitutional Amendment. Point is, people say, you can't advance your own case in the name of judicial activism, judicial legislation, right? And where is the objectivity here? There is subjectivity. Historical wrongs cannot be, compensated by the present day adventures. Maybe this is one such thing. What happened between 1973 and 77? The superstitions, the concept of committed judiciary. Okay, fine. That was emergency, kind of era. But whether that should ultimately draw our attention or lead to kind of judicial legislation, almost changing the constitution itself within the parameters of the constitution is the primacy of the judiciary envisaged by the framers of the constitution. This is the limitation I'm trying to talk about. Because the framers of the constitution never envisaged the supremacy of any organ of the state. Neither legislature, nor executive, and nor judiciary. However, the judiciary goes on expanding its horizons. And maybe judiciary may think that it's omnipotent, omniscient, right? Omnipresent, nothing wrong in it. But at the same time, there are certain, again, the lines of control which have to be respected. And probably it is better for the judges themselves to come out with their own line of control. You can't expect the other organs to do the exercise. And when they're done, what happened, you see, in the case of 99th Amendment and how it fell flat. That's one more issue. Then we have other issues. For example, Vishwa mission. The case was in 2001 regarding the guidelines relating to ragging in schools and colleges, education institutions. We have a well-made legislations in almost all the states on prohibition of ragging. This was not necessary, but still they say, like what is the in fact mechanism to be followed. Similarly, in the case of disposal of the food grains which are lying in the godowns, you must have calculated that. The case was PUCL in Public Distribution Matters versus Union of India, 2010. This judgment is welcome. Honestly speaking, even if this rice is given free of cost, the government is not going to lose anything. Because they say that there are, very huge quantities of rice grains in our godowns, right? Of FCI and many others. But the government of the day is not, exhibiting much interest about living relationship. Supreme Court is giving guidelines, is it not? You look at the case of Swami versus Pachayama, incidentally from state of Tamil Nadu. So living relationships, what Supreme Court did was only to recognize the position under Domestic Violence Act indirectly, saying that living relationship includes something similar to domestic relationship, but it's not a weekend outing, not weekend outing. Both of them must be single, then there is something like matrimony, and they must be present to the world at large that they are married to each other. This is one more important issue. Then there are, for example, one more very interesting thing. In Urdu, there is a saying, if husband and wife are agreeing, then what can Kaji do? Something like that. If husband and wife, they want to compromise, what can Kaji do? What can the religious go, the preacher do? Same is the case now. For example, a Hindu wife and husband want to get divorce. They want to be separated from each other by mutual consent. Can they do it immediately after filing the petition by mutual for divorce by mutual consent? 13B of the Hindu Marriage Act. But there are judgments today which say that it would be cruel to keep them, waiting for next 6 months. This 6 months period is wrong. There is a Supreme Court judgment. Devinder Singh Narula versus Meenakshi Nandala, which I will tell judgment. And the Supreme Court invoked Article 142 to say that the waiting period is only directory but not mandatory. In the sense that the presiding officers of the district court who is competent, he can grant or she can grant divorce by mutual consent without waiting for the 6 months of period which may be used for reconciliation. Right? Do you think that it's a good kind of judicial lawmaking by the judges? I don't know. The intention of the legislature may be to see that some kind of waiting period, some kind of period for introspection is given to both the husband and wife, so that they could reconsider their decision either to, cut this, either to, go for divorce or to, again, reconsider living together, husband and wife. But this is one such case. So there are many more, right? So Amazing versus state of UP, our red beacons are already explained. Nansha have explained. Then I explained about three Barnes case. What about the wine shops? Should they be 500 meters away from the national highways? Supreme Court itself went back on that. Initially, in state of Tamil Nadu versus K. Balu in 2017, the Supreme Court says, no wine shop shall be permitted within 500 meters from the main road because so many accidents are taking place. Valuable lives are lost. But today, that's not the case. Again, there is a relaxation. So what I'm trying, during this COVID-19 also, umpteen number of guidelines are given. Like, how the states try to go by to the social security laws, especially in the realm of labor and employment laws. How the judiciary came to the rescue with regard to migrant laborers, right? With regard to release of prisoners from jails for the purpose of preventing further spread of the COVID. Fine, this is one. But impact, as I can say now, impact has been tremendous as far as judicial legislation is concerned. But what we have to remember is that the mandate of the judiciary, whether Supreme Court or any other court for that matter, is not to rule, not to govern. Judicial governance is never contemplated either by the framers of the Constitution or by the constitutional pundits. No, they are very good to. Maybe in many of the instances, what they have done is laudatory. Certainly, it has to be welcomed. But at the same time, without proper coordination between political organs of the state on one hand and the judiciary on the other hand, what happens? For example, if there is a stubborn, adamant confrontationist government, which say that I don't want to follow your guidelines because they are in the nature of judicial legislation. We are there to make the law, not you. What are you going to do? Whether the content of court power can be extended to the extent of creating constitutional chaos. Again, I will quote Mr. Arun Shourie. Arun Shourie writes in that book, in fact, Justice P.N. Bhagwati, when he was not happy with the, in fact, the failure of the state governments, and sometimes even state high courts designated to, enforce the guidelines laid down regarding bonded labor prohibition, he said, if you don't take these guidelines seriously, we will view them out seriously. Means it was an indirect threat to invoke contempt of power. What kind of contempt power? Contempt power also has got its own limitations. Don't you think so? Who should enforce contempt? Do you expect the judges armed with rifles and sticks to come and enforce the contempt of court? If there is indifference or opposition from the organs of the state, the government, political organs, what can the judiciary do? This is only, in fact, a moot question. But what I am trying to say is that judiciary can act as a catalyst. Judiciary can always infuse life into the dry bones of the governance. It can awaken somebody who is sleeping. At the same time, judiciary can't do all those things which can be done by the judiciary. Otherwise, implementation will be difficult. Imagine how many common men in India know that these are the guidelines issued by the Supreme Court or High Courts, and they are binding on the government. And how many times these people can approach the court? Because this is not an omnibus or universal legislation. If it is a law, it is established in the Gazette, right? And it is notified. It comes into force from so day. Certainly, it can be enforced. But what about, in fact, the judicial legislation, the guidelines? Can you simply say that, suppose I go to a Tahsildar, suppose that, okay. Take for instance, one of my friends with me is pointing out, take the case of Shreya Singh's case. In Shreya Singh's case, I think yesterday, in the paper, first page, many persons, many police are still booking cases under Section 66A of the Information Technology Act in spite of the Supreme Court striking it down way back in 2015. Point is very simple. Every time we can't expect the beneficiary of such guidelines to approach the court or to file contempt petitions. Therefore, what is required is a concerted effort between the legislature, executive. Of course, in P. Ramchandra case, long time back, Supreme Court said, but the court cannot give a direction to the legislature to make a law on certain lines. Maybe that is one of the reasons why the judges themselves are trying to make the law. But look at the limitations, right? All of them are not complied with. No statistical data is collected. Therefore, in the ongoing development of constitutional jurisprudence, judicial legislation occupies a very important position. But one has to understand the needs of the society on one hand, legislative vacuum also on one hand, but in fact, it is only a catalyst, a reminder. Judiciary can make law interstitially. That's what one of the judges said, but not as a permanent solution to the problem, right? But as somebody said, Justice Crazy Politician in one of his speeches said that suppose, in spite of clear understanding, clear knowledge that the government must do something, but it is still not doing, what do you expect the people to go on whose doors to knock? Ultimately, they go to the judiciary. Judiciary has great respect, greater credibility, no doubt about it. But at the same time, they have to draw a line somewhere with regard to these guidelines. Otherwise, we can't expect judicial governance. So I'll stop here. I think I've crossed my brief, but I only hope that I could say something which is in tune with what's going on now. Maybe at least a few new things must have been mentioned during the course of my 1.5 hour interaction. Now let it be a real interaction if the organizers permit. Over to you, sir.
Thank you, sir.
Please carry on.
Yes, sir. Thank you, sir, for giving us a highly informative session. Sir, I think Okay, sir. Okay, sir. Thank you, sir. Thank you, sir, for giving us a highly informative session and making us understand lawmaking is an inherent and inevitable part of judicial process. I think I can say on behalf of every participant that it was truly an illuminating lecture. You've made us clearly understand the concept of judicial legislation in the light of enormous number of judicial holdings and by pointing out both its strengths and its weaknesses as well. One of the weaknesses being there is judicial inconsistency in the matters of judicial legislations itself and where the line ought to be drawn. So once again, sir, thank you so much for the clear and elaborate explanation of the topic. Sir, I humbly request you to stay with us for a few more minutes to answer a few questions from our side. The participants are welcome to post their questions in the chat box. I think there are already few questions which have been posted. So now let's begin the question and answer session. I'd like to invite my co-host, Mr. Ashwin, to take over the platform, please.
Thank you, sir. Thank you, Harini. Thank you, sir, once again for your wonderful lecture. I know we've had a little bit of trouble hearing you, but the lecture in itself was very enlightening because, as you mentioned, judicial legislation is a very it's a sort of a messy place to venture into, and you clearly pointed out certain important aspects of it and certain of its limitations. And I'm sure many of us have pointed out a few questions that may come that are a little more questioning towards the judicial legislation. And in India, so we have a question from Dr. N. Anbarasi. She says, in India, legislations by Parliament, when they are ultra vires of the Constitution, they are struck down by the judiciary. But at the same time, if there is a judicial legislation, a sort of a way where where judiciary overreaches a particular place, is there any way we can control like how the parliament is being controlled through judicial review. Sir, you're muted, sir.
I think it's a good question. If there is something wrong with the legislation made by the parliament or state legislatures, judiciary always in fact strikes down on the ground of constitutionality or otherwise. But when the judgment law causes some kind of inconvenience to the political organs of the state, they respond by trying to come up with a legislation to overcome the difficulty created by such, in fact, judicial legislation. I can give you the example of Justice Koka Subbarao led judgment in Devakna, and how the parliament got back by 24th amendment, which led to case of the Bharati. Same is the case with the other aspects, like how the second and third judges transfer cases, lay down the collegial system, strengthen the judicial system, and how again the parliament tried to dilute the same by coming out with 99th amendment, but again the judiciary got back. So it is an ongoing process, but at the same time we can't stop the parliament or the legislatures from in fact overturning any of the in fact judgments or judicial legislation made by the. There are two options. Without going for the ego or ego problems, what the legislature can do is to bring out a law if it is really satisfied that there is a need of such law. It can improve the law. For example, like the case of Sexual Harassment Act 2013. Otherwise, it will definitely try to overturn the judicial legislation. But people are the better judges, they have to influence the lawmakers in coming out with the necessary laws.
Yes, sir. And we can conclude the session with just one more question. So there's another question from a participant. He asks that we've known through various cases, as you mentioned, Sir, Lakshmikant Pandey with the Union of India, Shaira Bano, Common Cause, a lot of cases where judicial activism has actually closed the gap that was left open by the legislature. So at this point, clearly the judicial lawmaking is in a way positive for the public. So why should there be any limitation?
Ashwin,
That
I
is the
think
question.
Edumane
Ashwin?
sir is online.
Ashwin, is it audible to you?
Yes, sir. Yes, sir. I can hear you.
Sir, GP Reddy, sir, you have touched a lot of gamut of issues, but I would like to have your thoughts on following issues. Is it audible to you, sir? Hello?
Yes, yes, sir.
Sir, I would like to solicit your views on the following issues.
Yeah.
You have rightly said these precious recruitment rules has violated the constitutional rules or constitutional guarantees given by the constitution to the governance powers and the various public service commission. Supreme Court has indirectly captured a power to put their own people into the services. Would you like to suggest any cooling period for the judges after their retirement before they assume any new offices, because this area neither regulated by the judiciary nor by the parliament after their post-retirement job, sir? Sir, next question. Since you are an academician, you have also touched about the separation of powers. Nowadays, many national law schools are headed as a chancellor by the judges. Even some judges are occupying vice chancellor position. And lastly, I would like to solicit your views on judicial discipline and judicial accountability, sir. The three things I have asked you. I would like to solicit your views, respectable views on that, sir. Thank you, sir, for a wonderful lecture. Thank you, Harni, for giving me this opportunity.
Thank you, sir, for raising three questions. The very first question is about, in fact, the appointment of the judges. Honestly speaking, I am a student, very raw student of constitutional law, and I feel that one cannot be judged in one's own class. And especially, I sometimes when my young students ask me this question, so how can the Supreme Court be judged in its own cause? And sitting judgment over its power to its efforts to gain primacy from the executive in the matter of appointment of judges of the higher judiciary. Same is the case with the subordinate courts, sir. Honestly speaking, it is the public service commissions which used to exercise the power of appointing lower judiciary judges in the lower days. But slowly and gradually, the judiciary, in the name of regulating its own, internal affairs, has taken away this. And this is one aspect which I don't really support. Certainly, every organ of the state must be given its own due flexibility under the Constitution. This is first one, sir. The second one is about Mr. Ashwin. What is the second question?
Dr. Elamale, I think he can repeat the question, please.
Sir, the chancellor positions are assumed by judges in various national laws violating separation of powers.
Exactly, sir. But before that, your second question, sir, about the cooling period. Honestly speaking, pre-retirement judgments affecting post-retirement appointments, this is one issue which was highlighted by Mr. Alibetli also. Point is, people are not waiting, not only in the judiciary, sir, even in the administration also. Normally, there should be a cooling period, maybe 6 months, maybe 1 year, so that, in fact, the record of the person can be carefully gone through, and ultimately, whether the person is really deserving to become somebody. But unfortunately, it's not happening. I am a great supporter of the cooling period, and if possible, no further appointments, because India is not having any depth of, the experts in any particular field. Third one is about the national law schools. Any law schools for that matter, where the judges are either patrons or chancellors or vice chancellors. I think this is also something which certainly goes against the concept of separation of powers. Imagine a case. For example, I'm working in a national law school. I'm assuming that I'm working in a national law school, for which the chancellor happens to be the chief justice of my high court, and I have a service matter pending before me, or somebody is filing a case against my university, and the matter is listed either before the first bench or second bench or third bench. There is a reasonable likelihood of bias in favor of the institution and against the deserving petitioner. Therefore, I strongly feel that there must be separation of, because again, if I draw your attention to Article 134, eminent jurist in the opinion of the President can be made a judge of the Supreme Court. The judges have been shunning the, in fact, the legal academics with brilliance. I'm talking about people like, the great people like Prof. Osmania and many more, right? And when they have such a, in fact, an attitude. And second thing, when separation of policies coming in the way, probably they should desist from associating themselves with any of the academic institutions because of every possibility of a matter coming up before the court. I hope I answered this question, sir.
Right. Dr. Elamale, if there are no other questions.
Thank you, sir. Thank you, sir. You have answered me for all my questions. I'm very thankful to you, sir. Thank you, sir.
Thank you, sir. Thank you, Dr. Elamale. And I think we can conclude the question answer session. And so thank you, sir, for the enlightening session. Once again, for answering all the questions so eloquently. And I now request Dr. P. Balamurugan to give us all the vote of thanks. Welcome, sir.
Okay, thank you. Also, I will thank Professor Dr. Revati Madam for giving me an opportunity to deliver vote of thanks. And it is immense pleasure for me to deliver vote of thanks on behalf of the Tamil Nadu Ambedkar Law University. And also thank our today resource person, eminent speaker, Professor Dr. G.B. Reddy, sir. And I also thank the organizing committee for choosing a very wonderful topic, that is judicial legislation. I am also being a student of the administrative law. I know the theory, I also studied the theory of separation of powers. Most of the questions asked are connected with theory of separation of powers. But remember that, so before the state has become the democratic state. So you know that where the monarchy was followed, you take India, in England, still now monarchy is continuing. So there, you know that the judiciary, the king is the fountainhead of the justice, and he is the executive. And even the power is given to the parliament. It is the king's legislative power. Understand? So whatever the power that is given to the legislature, it is the king's legislative power. And likewise, what are the judicial power that is given to the judiciary? That is king's judicial power. And likewise, the king is the executive head. So we also followed the parliamentary form of system that is based upon the English constitution or otherwise English system. So in a parliamentary form of system, there cannot be absolute separation of powers, and there will be more concentration of powers rather than the separation of powers. So take for example, you can say that you take upper house of the England, that is the House of Lords. And you know that House of Lords is the highest judiciary in England. And that is also a part of the legislature. So the judiciary itself also forming a part of the judiciary. And likewise, if you take in India, not only the judiciary alone is legislating, executive is also legislating, executive making the legislation. Executive, parliament is also making the legislation. Understand? So we don't have an absolute theory of, we are not applied strictly theory of separation of powers. Judiciary is also given the legislative powers. For example, you can take Article 141 of the Constitution. Whatever the decisions given by the Supreme Court, that becomes a law. And likewise, don't think that that law-making power alone is given to the judiciary. You take a High Court or the Supreme Court, the rule-making power that is also given to the judiciary itself. That power is not taken by the legislature, or is not with the legislature. So the High Courts and the Supreme Court, they are framing their own legislation. That is also part of the legislation, legislative powers. So they are also making the laws. And likewise, the judiciary is also making the laws. But when the law is made by the legislature or by the executive, it can be reviewed by the judiciary. But in case, if the law is made by the judiciary, who will review the decisions of the Supreme Court or the High Court or otherwise the judiciary? This is more danger than the law made by the legislature or by the executive. Understand? But now we cannot absolutely apply the theory of separation of powers. So take for example, laws developed only by the judiciary. I can tell some example. Take administrative law. I'm being a student of the administrative law. You take administrative law. Administrative law is developed only by the judiciary. It's not a codified law. But now some part of the administrative law is codified. Take for example, a right to information. Now it is codified. And laws relating to corruption, that is also partly codified. So we have passed a Central Vigilance Act, and likewise now the Lokpal and Lokaयुक्त Act, all these things. So it is partly discodified. So still now we are relying upon the judgments given by the judiciary. So the administrative law is purely developed by the judiciary. And likewise, you can also take torts. Law of torts is still now is developed only by the judiciary. If you say that judiciary cannot make the law, you cannot study the law of torts. And don't think that torts means only particularly relating to the torts alone. See, lot of laws are separated from the law of torts. Take for example, you take contracts. You might have studied the general principles of contract or other rules of contracts. All are separated only from the law of torts. Understand? These are all based upon the decisions given by the judiciaries in various cases. Understand? So law of torts is also one of the examples where we can say that the law is absolutely, it is developed only by the judiciary. If you don't study the case law, you cannot study the law of torts. And likewise, you cannot study the administrative law. Understand? But the law, whether it should be given to the executive or to the judiciary, that is not important, but what is important is that it is the protection of the liberty and freedom of the individuals. So where the freedom and of the individuals can be protected, even if it is enacted by the judiciary also no matter. But if it affects the fundamental rights of the, or otherwise the freedom and liberty of the citizens, now where to file a, or where to file a case, or where we can seek a remedy, who will review, whether the judiciary can review its own decision, whether it will be biased or not. So all these questions that may arise. Understand? And likewise, now you know that that is where we are giving a lawmaking, why we have to give the judicial powers to the legislature. Because I told that in the constitution itself, they are given that judicial powers to the judiciary or to the Supreme Court is concerned. So I mean, the law is not whatever the law made by the parliament, that we call it as only a skeleton legislation. Understand? Everything cannot be detailedly discussed in the law. Even if you take a Indian constitution, Indian constitution is the lengthiest constitution in the world. Do you say that? Can you say that everything is dealt in the constitution? Well, it is possible. It has to be interpreted only by the judiciary. Understand? So what I want to say is that the law made by the parliament, even if you take the supreme law of the land, that is the constitution, it is only a skeleton legislation. Blood and flesh that can be supplied either by the executive or by the judiciary. Understand? So I don't want to take much of your time. Yes, sir. Yes, sir. Yes, sir. Please, sir. Sir, I cannot hear you, sir.
In fact, I wanted to thank Dr. P. Bal for enlightening us as to many basic aspects relating to the law parts, then the rule making power of the Supreme Court under Article 141, 145, so on and so forth. Sir, the discussion, because you are saying understand, I'm trying to understand because I think that is a catchline. Therefore, as I understood, what is precedent is something else, right? And judicial legislative power is something else. But making a proper law, issuing guidelines, etc., is not, in the traditional purview of the judiciary. When they are getting out of those powers, these issues do arise. When they are making laws under Article 145, Supreme Court rules themselves were struck down by the Supreme Court. You can remember that Plain Change Law versus Excise Commissioner's case. Similarly, precedent, yes, in common law countries, precedent is the life of the law. Ultimately, everything is in the form of precedent. There is no law of thoughts without precedent. There is no law of equity without precedents, right? And you're perfectly right. But I think we are on only one small point during the last maybe 1.5 hours. That is, if the judges are saying that since the parliament has not made any law, since the state legislatures have not made any law, we are making the law. It will have the force of law as it is made by the parliament until the parliament regularly makes the law. Here comes the main issue. Otherwise, whatever you said is absolutely correct. I am not in disagreement with you, right? I am just supplementing what you said. I hope I am not included into your vote of thanks. Please, sir.
Sir, your mic is muted. Balamurugan, sir.
What I want to say is that so whenever there is a failure on the part of the legislature, it is the duty of the legislature, judiciary. Understand? It is the duty of the judiciary to give directions or the regulations. Understand? So if you take the judiciary is the protector of the constitution. Constitution. Understand? So the executives and the legislature, they have to act in accordance with the constitution. Or even if there is any failure on the part of the legislature to make the law, that the judiciary gets the power to interfere or to make legislations. That is my humble view or humble opinion. Okay. Sir, thank you. I thank G.B. Reddy sir for giving me I thank Professor G.B. Reddy sir for explaining and for explaining about the judicial, about the laws made by the judiciary, what are the limits, what are the scope and everything. I thank G.B. Reddy sir for his wonderful session. Thank you, sir. Thank you very much, sir. And I also thank the Department of Constitutional Law, Professor Srinivasan sir, Professor Manjula madam, and Professor Elumale madam, Elumale sir. And I also thank the technical, I said, overall given the technical support for this webinar. I thank you all. Thank you very much.
Thank you, sir. This was truly a dual lecture for us. As sir already mentioned, you covered the basic points of judicial legislation as well. Thank you, Professor G.B. Reddy sir, once again for being a part of our lecture series. And with this, I suppose we can wind up for today. We've had a wonderful session, and I request the participants to please fill the feedback form before they leave. And we'll see you all tomorrow. Thank you.